He qualified in November 19 and has experience in fields of taxation and audits. He worked as an article assistant in Narayan and Company Chartered Accountants, wherein he provided tax and regulatory support and conducted financial and tax audit for clients in retail, manufacturing, and service industries. Post his qualification, he worked as assistant manager in Suresh Technology Company Chartered Accountants, where he advised on exit strategies for clients and retailers in conducting audits. Several of them worked as an associate in PricewaterhouseCoopers and Company Secretary, wherein he assisted numerous clients on corporate tax engagements, including capital gain advisory, mergers and acquisition transactions, due diligence, etc. Post his stint at PricewaterhouseCoopers Company LLP, he provided support to businesses on tax aspects as freelancer. He is currently associated with Up North Advisors as manager tax and consulting. On behalf of everyone, I welcome Say something for the
Thank you. We request SIRC of ICAI to present Namato to speak. Thank you, sir. Hand it over to speaker.
Before I delve into the deeper aspects about permanent establishment, if you just touch upon why permanent establishment analysis is relevant. So we all know that with the rapid globalization happening, and with India being an attractive investment destiny for Western countries, the foreign companies are interested in exploring business opportunities in India. So with this interest, they plan to set up operations in India, and through this cross-border operations, the PE risks arise. So when I say PE risks, it needs to be considered from the standpoint of both the local domestic tax laws and from the standpoint of the DTWs. So again, the permanent when I talk about investments from abroad, when I talk about investments from foreign countries, permanent establishment risks firstly arise primarily because they try to enter into a market and test the waters. They don't directly plan to set up a subsidiary in India unless they have a addressable market, unless they have significant business operations to address in India. So just to test the waters and in the initial stages of exploration of the new market,
they set up operations in any country, not just in India. They set up operations in a cross-border transaction, and this leads to PE risks. So we chartered accountants help most of the foreign companies set up operations in India, and it is very critical for us to have a high-level understanding about these PE risks. And with that context set, we will move into the basis of taxation. So under the Act, you all must be aware that taxation happens on two bases. One is on the basis of source and on the basis of residence. Under the Income Tax Act, if a person is a tax resident, the global income of the person is taxed. So an Indian resident earning income from US or from UK, such income is taxed if he is a tax resident. On the other hand, if the income is earned from India, regardless of whether the person is a resident or a non-resident, the income earned from India, that is income arising from India, is taxed. So when I say source, there are two categories in this. One is accruing or arising in India, the other is received or deemed to be received in India. Any income received or deemed to be received in India, that's quite straightforward. Anyone receiving the income from India will be subject to tax. The such income that is received in India will be taxed. However, our whole point of discussion will be entirely around deemed to be received in India, income that is arising or deemed to arise in India, and how that relates to how that transfers into analysis of PE implications. For the purpose of analysis, we under the Act, any income deemed to accrue or arise in India is covered under Section 9. Section 9 provides that any income earned through a business connection is taxable in India. So when we talk about business connection is a very wide term. Any transaction, any income earned by a non-resident, even if it is a small portion of their whole operations, or even if it's a negligible level of income, such income is taxable in India through the business connection provision. So analysis of business connection is straightforward. Whenever a non-resident earning income in India through a business connection or any business transaction, business connection provisions become applicable. So suppose if a person is earning income through a business operation in India, and the country from which the person is undertaking the transaction, if suppose India does not have a DTW, say for example a person is earning income from country X through a business operation in India, and this transaction is on account of a business activity. Suppose if the country X does not have a double taxation agreement with India, in that case Section 9 becomes applicable. Whenever there is a DTW available, whenever subject to satisfying other conditions, we always resort to the provisions of DTW. So the main point I am trying to make here is that Section 9 provides for business connection. Any income earned through a business connection is taxable in India, and the scope is much wider. However, there are guidance principles in the form of judicial precedents from the Supreme Court ruling in the case of RTA. While the Act has defined the term pretty widely, any transaction happening in India will be taxable as business profits. However, guidance can be taken from the ruling of RTA. So in the ruling of RTA, it has been provided that income earned through business operations should have some level of continuity, should have some level of it should not be temporary, it should have some level of permanence, and certain other significant criteria has been provided under RTA. So first thing we need to check whenever a person earning income from India through business operations is that whether the country from which he is earning has a DTW in India. If he does not have a DTW, business connection comes into play. when business connection comes into play, we can resort to RDA ruling to see if the guidance and the rules can be applied. So again, the analysis of PE becomes relevant here because, like I said, business connection is a wide term. For the non-residents to have some level of tax certainty. When we talk about tax certainty, and like I said, India being a very attractive investment destination, some level of tax certainty in terms of permanent establishment risks or the business operations risks for the non-resident investor is required. So there are certain conditions, there are certain relaxations provided under the DTAA in the form of conditions prescribed. Subject to satisfying those conditions, a person will be taxable in India only if he has a PE in India. So we will talk about that in detail in the ensuing slides. So if any of you have any doubts or want to get any queries, feel free to stop me then and there and get your questions. Now when we talk about permanent establishment, it's a concept mostly predominantly associated with the DTAA, the double taxation avoidance agreement. It is not in respect of, we cannot take any guidance from the Act for permanent establishment. Only provisions that has direct impact on permanent establishment is discussed under Section 92F and 44DA. Section 92F is discussed in the context of transfer pricing provisions, and 44DA is for non-residents having a PE. So only 44DA is the provision which has some level of impact on permanent establishments. The Act only discusses our permanent establishment and has a direct impact for permanent establishment per se in Section 44DA only. So for any guidance or for any interpretation issues, we resort to OECD or UN model tax and commentaries. Just to set the context here, OECD and UN model tax conventions are, they are like the reference points for any international tax disputes. They have a model tax treaty, and most of the treaties are placed between India and the overseas country is based on the models drafted by OECD and the UN model tax conventions. So, like I said, we place reliance on OECD and the UN model tax conventions rather than having our CTED guidance under that for the purpose of PTAA. So, once
PTA will be generally modeled on this UN model or basic?
It depends on PTAAs between each country. If suppose we can place reliance on either of them. OECD model is for developed nations. For example, US. Maybe if we have a DTAA with us. Those models are based on OECD principles. The commentaries provided under OECD model tax convention. So, whereas UN model tax convention is for developing nations.
Which means that is more like there is no kind of thing.
Exactly.
And PTA is the operating company.
Correct. So, if suppose we take India and Denmark DTAA, in that case we can place reliance on the guidance from OECD model tax convention and UN model tax convention. So, this reliance has been placed by Supreme Court and other Indian courts as well. Whatever inferences we make holds good, subject to satisfying the conditions. So, we have discussed about business connection and permanent establishment. So, the high-level reference is that business connection is a domestic law concept, like I said. Permanent establishment is an international tax concept. It comes into play only in the context of application of DTAAs. business connection is a non-exhaustive definition. The Act, defines or discusses about business connection in an inclusive way. It does not provide any specific condition for business connection to arise. It provides that certain similar transactions form part of or give rise to business connection, rather than specifically saying the conditions that needs to be satisfied for business connection to arise. Rather, on the other hand, P, permanent establishment, defines this exhaustively, quite exhaustively. There are certain scenarios and conditions that need to be satisfied for permanent establishment to arise. P, there are broadly 4 kinds of P's that we will discuss. We will discuss in the next slides. However, in business connection, there is no classification as such. I've emphasized that business connection is a wider concept, whereas permanent establishment, though per se it's a wider concept, relative to the business connection concept, it's relatively narrow. So these broadly are the clauses that discusses about permanent establishment. So generally in any article, any ETW between any countries, they have Article 5 to discuss about permanent establishment. So under each article there will be some clauses. Article 5 what generally discusses about the basic rule. When does a PE arise? And the basic rule is applied for a fixed place PE. And secondly, we have specific inclusions. There are certain specific examples given for each. Those specific examples are indicators to analyze the existence of a PE. And then another type of PE, 5.3 discusses about construction or installation PE. And what are the activities that do not form part of or does not trigger PE. These are basically preparatory and auxiliary activities. We will discuss about what those activities are in the forthcoming discussion. And then agency PE. 5.6 is about independent agent. So we talked about Article 5.2, Clause 2, discusses about specific inclusions. So we have a place of management, branch, office, factory, workshop, or any other places of extraction. These are indicators. These are, suppose if a non-resident has a place of management or has a branch in India, that is an indicator for us to undertake a PE analysis. Having a branch does not by itself create a PE. It is an indicator for us to analyze if this can give rise to a branch. This can give rise to a PE. And then we talk about specific exclusions. PE specifically excludes these are called preparatory and auxiliary activities. Stocking of goods, purchasing of goods solely for display, and certain other transactions are covered here. So when we say preparatory and auxiliary activities, if non-resident undertakes only preparatory activities or only auxiliary activities or any of these activities of this nature, it does not give rise to a PE. Again, it needs to be undertaken. It needs to be analyzed on case-to-case basis. Just because a non-resident undertakes only preparatory and auxiliary activities does not necessarily imply that it does not give rise to PE. We need to analyze this from case-to-case basis and see if there are other conditions prescribed under the Act that are satisfied. So, under the ETW. So, with that, we can move on to the discussion on the types of PE. Like I said earlier, we will broadly be discussing about 4 types of PE. One is fixed place PE, construction and installation PE, service PE, and agency PE. I'll give a broad overview about each of the type of PE, and then we can delve into deeper discussion about each of them. So, fixed place PE talks about the requirement to have a place of business. A non-resident must have a place of business for fixed place PE to arise. It can be in the form of an office, it can be in the form of even any space. It need not necessarily be the office. Example is that it can be office, it need not be office. So any space which they have can be placed to a fixed place PE. Secondly, construction or installation PE. Any construction activity that happens in the source country that attracts PE implications under construction PE. Service PE. A non-resident has some of his employees work in India or in any source country, then service PE gets triggered. And then we have agency PE. A non-resident might have an agent or might have a person on whom he has total control. Such kind of a control, essentially means that the non-resident has a presence in India. So the agent or the person who is acting on behalf of the non-resident is essentially an agent and subject to satisfying other conditions that can give rise to agency PE. So we'll move on to discussion on fixed place PE. So when talking about fixed place PE, it means that a fixed place of business through which the business of an enterprise is wholly or partly carried on. So there are three critical elements that are required to be present for fixed place PE to arise. Firstly, there should be a fixed place of business. Like I said, it can be in the form of an office or it can be in any other form, but a place of business should be present. And then that place of business should be used for carrying on business. It is not, a place of business is available for the business, but the place of business is not used for any business activity. In that case, PE risk will not arise. Only when the place is used for business purposes, the fixed place PE risk arises. And we perform these three tests that is for the place needs to be fixed. There should be a fixed place for which we do location and permanence test. And for the place of business, when I say the place or a fixed place, it needs to be at the disposal of the taxpayer. It should not be that he just uses a place and just because he uses a place, it gives rise to a PE. That is not how fixed place PE implications arise. It needs to be at the disposal of the taxpayer. We will discuss about the disposal test and carrying on business through such space. What qualifies as carrying on business? Whether carrying on preparatory auxiliary activities like it's told they are excluded. Does that qualify as business? Or any other test that we can do to analyze if that can give rise to the. So all these are essential components. There should be a fixed place of business. There should be the place of business should be used for carrying on business. If any one of these elements are absent, fixed place PE will not arise. We move to the location and permanence test, which is to test if there is a place, whether that place can qualify as a fixed place, and whether that place gives rise to a permanent establishment. Now, we say place of business should be a distinct place. So, take an example. For example, there is a trade fair in Chennai. A merchant sets up stall in various places. Say, for example, it happens in the trade center, and the trade fair happens for a week. And each day he changes his stall within the trade fair. Though the place changes, though the stall he sets up changes, he will satisfy the location test. We cannot go back to say the geography, or we cannot say that there is no fixed place in this case. The understanding we need to have is that the place of business, or in this case, the trade fair is the place within which he sets up the stall. It is not that he has set up a stall outside the trade fair. Within the trade fair, he can move around and he can set up fair any place he wants. But just because he is moving around within the trade fair does not mean that he does not have a period. So, if it is within a fixed or a distinct geographical place, it can be considered that he has a fixed place of business. In this example, take another version. Say for example, he sets up a stall today in Chennai in a trade fair, and he sets up a stall in Delhi tomorrow. In this case, it cannot be said that he has a fixed place because he is not having a specific place for connecting business. One day he is present here and the other day he is present in Delhi. The stall present in Chennai for one day and in Delhi the other day does not necessarily trigger fixed place being. Secondly, existence of geographical and commercial coherence. So let's take another example here. There is a building, and in the building a painter does painting work. If the painter undertakes the painting work for the building as a whole, is there commercial and geographical coherence? So before I discuss in detail about the commercial, discuss about the example, what is commercial and geographical coherence? In the stall that is being set up in the trade fair example I discussed, there is geographical coherence. So he sets up a stall in a fair in Chennai. It is a commercially coherent transaction because the fair is in Chennai and the stalls he set up is in the fair. So if he is setting up a fair outside of Chennai, it is not in relation to a transaction in Chennai. So that is not a commercial coherent structure and geographical coherence also. So coming to the painter example, if there is a building and the painter paints for the whole building, that is a commercially and geographically coherent transaction because there is a fixed place, there is a defined space in which he is performing the work, and it is for one single project. It is not for different 2 or 3 different projects. There are not many projects involved. So there is geographical coherence in the form of one building and commercial coherence in the form of one single contract. Take another example where in the same building, say there are 5 or 6 floors, and he is given a contract to paint only for 4th floor and 3rd floor by 2 different contractors. In this case, there is geographical coherence because he is working in one specific geography, but there is no commercial coherence because the requirements of each contract might differ and it is not for one single party. So there needs to be commercial and geographical coherence. The work undertaken needs to be in a specific place, and it needs to have some commercial rationale for these to be considered to give rise to a fixed place fee. And a straightforward point, the business needs to be carried out through the place of business. In this way,
the painter example that you gave.
Yeah.
So if the painter is a non-resident,
Correct.
right? Whether for the painter, whatever income that he makes out of it, whether that's considered as an income out of the permanent establishment, correct? So that's what is the test that we are doing here. So the same painter example for different floors that you gave. How is it different from the first example of Shanita? 2 scenarios you gave.
So in the first scenario I have given, there was one building and the painter undertakes for the painting work for the whole building under one single contract. Okay. And so the terms might differ or terms might not be different. There is one single contractor and the terms will be the same. However, in the second case, the place is the same. There is geographical coherence. However, commercial rationale, it is not the same. It is different. So we cannot say that geography, it can give rise to a fixed place fee. So what I'm saying is that both geographical and commercial coherence must exist. Because if suppose in the same example, one single contractor has provided the contract for both of those, it is just an extension of the first example. In that case, geographical and commercial coherence will apply. When we talk about commercial coherence, it needs to be one single project or it needs to be one single activity, like meaning similar contracts. In a we cannot say two dissimilar contracts exist in a single place, so fixed place PE arises. The activity needs to be similar for any project we undertake. Is that clear? Okay.
I think I'm probably missing out on the fundamental. So you are saying if there are two different contractors, so those two different contractors are two different companies, let's say both are non-residents. Yeah. So in this case, the payment that is made for the non-resident, so whether it has to be considered as arising out of PA or not, but it's depending on whether it is a PE or not, right? So this is what is the overall
discussion.
Yeah. So can you just come again if both the contractors are non-residents in that case? Okay, two different flows that you are referring to. So how you are saying that there is no PE established here? That's what I am not able to.
Yeah. So the commercial rationale needs to be the same. So for example, the first contractor might have a different need. For example, he might require painting for only one floor. The second contractor might require painting for whole floor. It's a two different contracts, right? The specifications of the requirements are different. So I cannot say the entire building or the geography is at my disposal or that gives rise to PE just because I do work in the same place. The work I do needs to be similar for it to give rise to a fixed place. Is that clear?
Yeah.
So we talk about permanent establishment. So there is a certain degree of permanence expected. In which respect is this permanence test required is in relation to the business activities undertaken. So the first question when we talk about permanent is business activity or the business activities required to be everlasting? Should it be a continuing activity? The answer is no, it need not be. It needs to be analyzed on a case-to-case basis. Only requirement is that it should not be temporary, it should not be a one-off case, or it should not be transitory. So we have a case. Say for example, a non-resident has a presence in India only for 3 days for a work. Will that give rise to a permanent establishment? Subject to satisfying all the other conditions. Will this short period of time give rise to permanent establishment? Any thoughts? Right. So this time limit, especially in the context of fixed place PE, time limit is not the main criteria. However long the business activity can be, or however short the business activity can be, subject to satisfying all the permanence, the location and the permanent stress and disposal risk will come to this. Subject to satisfying all the other conditions, we can check for fixed place PE, and fixed place PE can arise even if the activity is for a very short period of time. The example I discussed about is the case of Formula 1. Car races are conducted in Delhi, and the car races were conducted only for a short period of 3 days. And the entire place was at the disposal of the company Formula 1. And any how do you put this? Please. Sorry. So Formula 1 had the place at its disposal, and the place was used for conducting its business activity. The business activity is to conduct races, and earn income from sponsorship and other revenues. So even though it is only for 3 days, the Supreme Court ruled that the nature of the business itself is such you only do the activity for 3 days. Does not necessarily mean that you have to do the activity for the whole year to give rise to a fee. So Supreme Court held that in the case of Formula 1 World Championship, that even though the activity is for a very short period, it can give rise to fee. And any questions on that?
Supposing a foreign company is scrap and is disposing of fixed asset as scrap, and the Indian paper company acquires it as a plant machinery, so this is scrap it for the seller, so fixed asset for the buyer. For this purpose, in 2 years from the seller's company come to India, assist reconstruction of the scrap paper machine. Will this constitute?
This will get covered under construction or
Installation.
or in service fee.
Yeah, but it's not installation. There is a scrap for the seller.
It will still qualify as a construction because we can come to that discussion later. But just to address your point, construction fee does not necessarily mean construction of building or any structures. It also involves construction of machines and installation of machines as well. So though it can be scrap for accounting purposes or for business purposes of the non-resident, what is actually happening in substance is that the machine is being installed or commissioned in India. So supervisory or installation fee needs to be analyzed in that state, in that case. So next is disposal and business activity test. Whether a taxpayer can have a fixed place and the taxpayer can undertake business activities. However, if the fixed place is not at the disposal of the taxpayer, it will not give rise to a fee. Self-explanatory question: whether large space required, whether even a small room as tiny as 10 cross 10 feet room, will that be sufficient enough to give rise to a fixed space fee? The answer is yes, regardless of whether the size of the space or the fixed space is small, or regardless of whether the size is bigger, it can be giving rise to fee risk. And whether formal legal right to use the POV required. The important aspect we need to consider here is, nowhere in the DTWs it is specified that the non-resident should occupy the premises illegally. Even if a non-resident is occupying the place illegally, and even if he does not have any legal right to use the property, it can give rise to a fixed place fee. Provision to use facilities. Say for example, a non-resident seller or non-resident seller's employee approaches an Indian company, and the Indian company's facilities are being used based on the permission from the Indian company. Say the facility can be for making for coordination activities with other customers or for potential customers, for any activity. But the usage of the facility is only based on the permission granted by the Indian company. In that case, will the disposal test be satisfied? That answer is no. Just because they have a permission does not mean that they have the disposal over the location or the fixed place. And nextly, we have the requirement to carry out business to the place of business. Before we discuss about the carrying out business, any questions or any doubts on disposal test. Right. So
when you say permission to use facilities, is actual use of facilities or just permission on paper? That is the
just mere permission is not sufficient.
some activity has to happen.
He needs to have some sort of control or some sort of or I wouldn't say ownership.
Responsibility.
Yeah, the place is available to him at all times. With
What is the availability? What is the actual work happens there?
yes, that's the next.
That's the next step. Sorry.
Yeah.
Sorry.
So, with respect to the availability of space, it needs to be available. Just because he is allowed to use the premises by another person does not give rise to a fixed space, or it does not satisfy the disposal test. And lastly, we have business carried out through the place of business. Should the activities be productive? Can the activity be preparatory? The answer is not necessarily. It need not be productive. There is a ruling by High Court which says that in the grand scheme of or in the when taken the organization as a whole for the non-resident, if even non-productive work, which is critical for the core income generating activities of the non-resident, such non-productive work also will be considered to be business activity, and that will be considered as business activity carried to the place of business. So it is not necessary that the business activity should be productive. It's sufficient that it is supportive, or it is a supportive function to the core income generating activity of the non-resident. So before we move ahead with construction, any questions about fixed place P? So I can just summarize the discussion on fixed place P. Firstly, there needs to be a fixed place of business through which business is carried on, and we have three tests undertaken. One is location and location test, location and provenance test, and disposal test. Location test is that there should be a place. We have seen certain scenarios where it need not give rise to a place. It cannot be considered as a fixed place of business. The painter example we have seen, and the market stalls example we have seen. And then we talk about permanence test. The duration of the business activity is not is immaterial for ascertaining the fixed place to be. And lastly, we discussed about disposal and business activity test. The property needs to be at the disposal, regardless of whether they are occupied legally or illegally, or any other form of occupation. And lastly, such place should be used to carry out business activity. Even if they are not productive, if they are supporting the business operations of the non-resident, it can give rise to, or it can satisfy the business activities. We can move to construction and installation B. So, unlike in fixed place B, where you need a fixed place of business for permanent establishment to arise, in this case, work done and satisfaction of the time limit, satisfaction of time to, when I say satisfaction of time, work needs to be undertaken in India for a specific period of time for construction and installation period to arise. I mentioned about UN and OECD model. OECD model is for developed economies. It's usually intended for developed economies to adopt, and UN model is for developing economies to adopt. When we talk about developed economies, they have some sort of relaxations. The provisions or the tax rules are not as restrictive. However, UN model is bit restrictive in taxes. So going by the understanding of UN model being restrictive, we can see that the construction P gives rise to, construction or any installation activity gives rise to a construction P if the activity lasts for more than 12 months under your model, whereas under your, 12 months under OECD model, whereas under your model, it is brought down to 6 months. So we need to pay close attention to the time limit specified in the respective PTWA and see if the time limits are reached. Nextly, we have in construction P, we included at the other clauses if the conditions are not satisfied. So we have the discussion about construction P in clause 5(3). Supposing if the time limit, say 12 months or 6 months, is not satisfied. If the time limit is not satisfied, can we go back to fixed place PE and say, if construction PE is not arising, we should check for applicability of fixed place PE. The point here is that there is general principle in income tax. Specific provisions prevail over the general provisions. Since there is a specific clause in the DTWA to discuss about construction and installation P, we cannot resort back to fixed place PE to see if PE risk arises. So typically the tax authorities do this. They check for applicability of construction PE, and in such a in case if the construction PE applications are not relevant, they resort back to fixed place PE to see if those implications are relevant. But the point is that it is not necessarily, it cannot be done. When a certain type of activity is specifically discussed in one clause, we cannot go back to another general clause to tax it. Lastly, whether only construction of building is covered. The answer is no to answer your question, sir. The construction of buildings, the construction of roads, canals, any structure, installation of even construction of plant and machinery also gets covered. Any sort of construction activity in substance needs to be considered. We talked about permanence test in fixed place P. For the purposes of construction and installation P, we consider duration of the project. That's the permanence test. It is the equivalence of permanence test in construction PE. So, like I said, it needs to be either 12 months or 6 months, depending on the DTW that is applicable. So, when we talk about the time limit to be reckoned, ascertaining the time limit for which the work is carried out, will it be reckoned from when the preparatory work for the construction commences, or only when the actual work commences? Say, for example, a non-resident sets up a project office or a planning office in India, and he surveys the land and he, undertakes diligences, viability tests, soil tests, etc. In that case, will the planning activity be considered for the purpose of, computing the time limit, or only when the actual construction commences will the time limit be considered? The issue here is that it is not a clear-cut case. Ideally, the Delhi High Court has ruled in a case that it needs to be considered from the time of planning itself. It is not necessary that the time limit should be considered from when the actual construction begins, because it does not, sit in harmony with the OECD principles. Because the construction PE in itself is, intended to cover, even the activities that are important for undertaking the construction activity. So, when we talk about planning, it is essential for the construction activity. Without the planning, the construction cannot commence or it cannot be undertaken. So, that forms an integral part of the construction activity, and hence the Delhi High Court has taken a view that even the preparatory work needs to be considered. However, a recent ruling by the tribunal has mentioned that, has observed that it is possible to take a view that only when the actual construction happens, the time limit will be considered. So it is very critical to understand the facts of the case and highlight the potential risks with the client in that case. And since it is not a clear black and white situation, we need to be mindful about the legal precedents as well and take a decision accordingly. Again, in the case of computation of time limit, whether to consider negotiating period computation of time limit for preparatory work. So, like I said, the preparatory work is included. Whether the negotiating period is to be considered for computation of time limit. This is a fairly clear case where it has been provided that if the negotiating period need not be included because it is not an actual work, unlike the preparatory work. The negotiation does not necessarily, it need not necessarily result into a contract. So, you want to So, negotiating period need not necessarily result in a final contract. So, that time limit for negotiating the terms need not be considered. Whether time spent by subcontractor to be prepared, it's a very important point. Supposing a non-resident has a construction work and he subcontracts the work to a person, whether an Indian resident or a non-resident. In that case, whether the work undertaken by the subcontractor will be considered for the purpose of computing construction PE timelines. The answer is yes, because it will be considered that the non-resident is undertaking the work himself. So that is a critical point. And whether seasonal or temporary interruptions to be considered. Say for example, there is a bad weather or anything that is beyond the control of the non-resident. In that case, will the interruption, the period where the service or the construction work has taken a break or it has not completed or it has not been undertaken, can that period be included? It is basically not a favorable situation if it is included, right? But unfortunately, it has been provided that in the OECD guidelines that seasonal or any temporary interruptions shall be included for the purpose of computing the time limit, and the time limit needs to be reckoned accordingly. And another important aspect, the considerations we have here will be relevant for service PE as well. When we come to service PE, we will discuss about that as well. But one important aspect is whether we need to consider solar days or man days. Say for example, a non-resident deploys 100 or 50 employees in India for undertaking a construction project. In that case, 50 employees have worked for 10 days. Can the number of days be considered 500 because 50 employees have worked for 10 days? Will that be 500 days, or will it be 10 days, regardless of how many number of employees worked in India? It's the solar days. It's not dependent on the number of employees who work. It's dependent on the number of days they actually work, regardless of how many employees or the members work. And we talked about the time limit. The time limit is 12 months or 6 months. Whether it needs to be considered on a rolling period or in the previous financial year. Say for example, suppose a non-resident starts work in September. Will the test be undertaken starting from September for 12 months or from the in the previous financial year? It is a dicey position, it is not a clear position, but it is recommended, or it is safer to consider the rolling period, that is starting from September rather than considering the previous financial year. However, there is a ruling to say that the previous financial year can be considered. Having said that, it is better to adopt the position of considering the period from the day when the project commences. So, aiming to adopt the period from the day when the project commences. So, we talk about supervisory activities. When we talk about supervisory activities, it is part of the construction fee. It is not a separate fee as such. So, for example, a construction project will involve different elements. One could be for construction, one could be for installation. And as part of all these, there could also be an element of supervisory activities. So, supervisory activities is subsumed in the construction or installation fee. We need not see that as a separate type of fee. But certain it is important to understand the relevance of supervisory activities in the permanent establishment implications. We need to see if the supervisory activity is undertaken in connection with the construction or installation. If supervision happens for any other activity, say for example, there is a project construction happening in place X, however supervision happens for a project in place Y. The supervisory activities should not be for place Y, it should be for a process happening in place X. So it should be in relation to a construction or an installation. It should not be looked at in isolation. Aggregation of projects. This is a critical aspect. Construction or installation fee, like I said, will have different elements. Could be for construction, could be for installation, could also contain supervisory activities. In that case, is it possible to aggregate all these projects and say the number of days we consider should be applicable for all three types of activities? So, one is construction, installation, and supervision. For all three, should we say we need to club them all together and reckon the time limit accordingly, or should we say that each element needs to be ascertained separately? The answer is, if we have sufficient documentation, if we have sufficient evidence to support that each activity is undertaken independently, they are not linked together. In that case, we can clearly say the time limit applicable for construction will not be applicable for installation and supervision, and likewise for the other three fees also. However, if they are interlinked, if they are very closely linked together, in that case we cannot escape from the time limits. Everything needs to be combined, and the time limit needs to be reckoned accordingly. So whatever work they do, say for example, they work X number of days in construction, X number of days in Y number of days in installation, and Z number of days in supervision. If they are part of one whole project, if they are very closely linked together, in that case, the number of days worked on all three projects needs to be considered together for computing the time. Nextly, we have whether to consider from the date when supervisory activity commences or from the date of commencement of the project. This is a very interesting point. When the supervisory activity commences, when the relevance of supervisory activity comes in only when construction or installation happens, right? So whether the number of days time limit should be considered from the date of actual construction. Supervision can happen maybe after a point in time. Say for example, a contract can have a clause that says the non-resident or the person doing the construction is responsible for supervision only after 20% completion of the project. Or you can have any clause that says supervisory activity commences after a certain period. In that case, from when does the supervisory activity timing consideration arise? answer is only when the supervisory activity commences, not from when the construction begins. Only timelines relating to the supervisory activity needs to be seen. However, we talked about application of projects. If it is part of a whole project, if it is very much interlinked with the construction activity, the supervision activity is very closely linked to the construction and installation activity. In that case, it needs to be from the date of construction. So we come to agency PE. So just to give you a context here. Sorry. Just to give you a bit of context here, a non-resident can have a presence in India, in any other country through another person. It is not necessary that they need to be physically present or they need to do some activity in the other country for the PE implications to arise. The other person who is acting on behalf of the non-resident can also undertake the activity, business activity, as if the non-resident is having a permanent establishment in India. So to address those issues, agency PE has been, brought into the PDWS. Now, agency PE is applicable only for a dependent, only if the agent is a dependent agent. If the agent is undertaking activities on an independent basis, not dependent on the non-resident undertaking the activity, in that case, the non-resident will not have an agency PE. He needs to be a dependent agent, and the person is acting on behalf of the enterprise. Just because a person is dependent does not mean that it should give rise to agency PE. The person who is dependent on the principal needs to act on behalf of the non-resident, unless there are any activity that is done on behalf of the non-resident or it gives rise to some sort of impression that the non-resident is carrying on business through the person in the source country. Agency PE will not apply. And lastly, the person has authority and habitually exercises the same to conclude contracts. A dependent agent, he should have the authority to conclude contracts. If he is not having the authority, or if he is checking back with the principal for every small thing, it does not give rise to agency PE, and he habitually exercises such authority. It is not in isolation, or it is not in stray instances that we can say that he has exercised this authority, so agency PE is arising. That is not how they should be looked at. They should be looked at only on the basis that the person has the authority and he uses that authority to conclude the contracts on a regular basis. And we have certain tests to check about who is a dependent agent. So before we discuss about the dependent agent, first thing, like I said, I'd like to reiterate, agency PE is applicable only for a dependent agent. At any point, if you can prove that the person is independent of the non-resident, agency PE gets pulled out. So, how do we ascertain if the person is a dependent agent? Firstly, we check about whether that agent is legally and economically dependent on the non-resident. Because one example could be that one scenario or one indicator could be that the person is economically dependent on the principal is that. Suppose if he has only one principal, that is, he takes instructions only from the non-resident and not from anyone else. In that case, it gives rise to, it can be clearly said that it is an indicator, it is not a conclusive rule, but it is a clear indicator that he is economically dependent on the non-resident. So it needs to be undertaken on a factual basis and on case-to-case basis. If there is legal dependence, say for example the agent, if the agent is legally obligated to check, or if the agent is legally obligated to get the consensus of the non-resident before taking any action, he is not legally independent. He is legally dependent on the non-resident. So it is a factual exercise. The entire P analysis is a factual exercise, but these are just broad indicators to see if any P exists. So whether for the purposes of agency P, holding company having a control over subsidiary, whether it is relevant or not, just because non-resident has a subsidiary in the source country, just because there is a holding company subsidiary company relationship, does this mean that the subsidiary is acting on behalf of the holding company? The answer is no. Again, it needs to be seen on a case-to-case basis. Tax authorities take the view that though it is not relevant, they take a stand that the voting rights and the holding company influence is used to undertake to make the subsidiary undertake agency functions for the holding company. So while it is not relevant, it is the stand of the tax authorities that the control exercised by holding company can, it is not a conclusive thing, but it is a thing. It is a factor they consider to say that agency exists. And another important aspect that we can consider to see if the agent is a dependent agent or an independent agent is supposing any agent, whether he is dependent or independent, they are responsible for the results of the work to the principal. So supposing if I have an agent and he is dependent on me, he is responsible to me for the work. And supposing if the agent is also working on behalf of another principal, he is responsible for both myself, on whom he is depending, and the other person on whom he is not depending. He is responsible for the results to both of us. However, if I can control him on how to do the work, how to get the results, if I have control over how each and every function he does or he undertakes, in that case he is dependent on me. I cannot rule out the possibility. We cannot say clearly. That in that case he will be dependent, but it is a critical element that we can consider. And next, we talked about certain prerequisites. One is that the agent should be a dependent agent, and he has authority to conclude contracts, and the other one is he should be acting on behalf of the enterprise. And when coming to definition of authority to conclude contracts, he should have the authority to decide the final terms of the contract. It should not be just a negotiation, or it should not be the declaratory terms of the contract. It should give rise to an obligation for the non-resident, and some sort of finality should result as a result of the authority exercised by the agent. The contracts need not be entered literally in the name of the enterprise. So here again, substance over forms comes into play. If the contract is entered, even if it is not in the name of the non-resident, but it gives rise to obligations to non-resident, and it furthers the business operations of the non-resident, in that case again, it can be considered that the agent has undertaken operations on behalf of the non-resident. So just by the legal paperwork that he is not concluding contracts on behalf of the non-resident, he cannot escape the agency implications. Again, I discussed about this obtaining approval before signing the contract. For every confirmation or for any decision relating to concluding the contracts, the agent requires the approval from the non-resident. In that case, it cannot be said that the person is independent. And soliciting orders with the business authority to conclude contracts. When we talk about soliciting orders, say for example, the agent helps in attracting customers or helps in only soliciting orders. These need not necessarily convert into final business operation or any sort of obligation for the non-resident. But can that be considered as authority to conclude contracts? The answer is no. But again, it needs to be seen on a case-to-case basis. Suppose if soliciting the orders is the main function for the non-resident, if soliciting the orders or doing that specific function is the business of the non-resident, then in that case it can be considered as the authority to final.
The last point, the earlier one, obtaining approval before signing the contract versus soliciting. First we said it's dependent. It's not independent, it is dependent.
First, can you repeat it?
The last dot.
Right. Obtaining approval.
Obtaining approval. So if you want to obtain approval, he says it's dependent. Correct. Now soliciting we say it's not dependent. But both almost the same. See, if I solicit, that means I need an approval, and only then I'll be able to conclude or I can consummate the contract. But supposing I'm not able to find out the difference between these two, but whereas these two are totally different. See, obtaining approval before signing the contract, we say dependent. Correct. Soliciting, we say it's not. It is not dependent.
I'm not saying it is not dependent, sir. Soliciting orders.
So what will the difference between the last?
It is only a specific instance. Say for example, he is trying to bring in some orders for the non-resident. In one business situation where the non-resident you or the agent brings in some business work for the non-resident, it need not necessarily result in the final contract. It need not result in some final terms for the non-resident. Whereas before signing the authority, before concluding the contract, the agent gets the approval from the non-resident. That is dependent, that is clear. But here we are talking about soliciting orders as authority to conclude contracts. Here I am giving you one specific business instance wherein just the soliciting of orders, will that lead to authority? Will that be considered as authority to conclude contracts? That is again on a case-to-case basis needs to be seen as what I am saying. I am not clearly saying that it is dependent or independent. I am just saying the solicitation need not result into final terms of the contract, and it needs to be seen on a case-to-case basis. The authority to the contracts that he concludes, it should not be for any activities other than business operations. In that case, we should not see the agency fee implications. Rather, only for business operations and contracts concluded for business operations needs to be considered for agency fee implications. That's for agency fee. Any specific questions? Nextly, we have the last type of fee, which is the service fee. Service fee again is an extension of the construction fee. UN model discusses service fee under construction fee itself. So service fee is covered under construction fee itself under UN model. The important trigger point for service fee to arise is that the non-resident should send some employees on deputation to the source country to do some work. It is important for the employees to be deployed for a certain minimum period of time for the service fee implications to arise. So the DTW provides that services shall be performed by employees or other personnel engaged by enterprise, and such activities continue for more than 12 months. The time limit applies, unlike in construction, anyone can undertake the work. It is applicable only for employees and other personnel. So when we talk about other personnel, if suppose contractor, like we discussed for construction fee, a contractor is sent for doing some services in the source country. Can the other personnel be triggering service fee? Answer is yes, they can trigger, provided there is one important consideration here. The other personnel should be subject to the same level of supervision that the employees are subject to. How much of a control the non-resident exercises on the employee, the same level of control needs to be employed on the other personnel as well. So, if such other personnel are subject to the same level of supervision like the employees, in that case, it can give rise to a service fee. Unless the supervision condition is not satisfied, it cannot give rise to a service fee. And other important consideration for service fee is that employees should visit India. They should not be working remotely for service fee to arise. For the visit to India is a mandatory condition for them to trigger PDS. We discussed about solar days and hand days. It should be the solar days that needs to be considered. So when we talk about service fee, we should also talk about Article 12. Article 12 of DTAA discusses about fees for technical services. Fees for technical services are basically covered under Section 917 of the Income Tax Act. It provides that any activity in nature of technical, managerial, and consultancy nature should be taxed on the should be taxable in India. Will be deemed to be accruing or arising in India. DTAAs provide that such income are taxable on gross basis. Any income in the nature of FTS is taxable on gross basis and it will be subject to withholding in India. However, certain DTAAs have service fee. So if a specific service is provided through employees, will that be treated as a service fee, or will that be, any income arising from such activity, will that be treated as income from service fee, or will that be treated as income from fees for technical services? This is something of an area where we don't have much clarity. It needs to be analyzed, and this issue needs to be clarified by the judicial presidents. However, in Indian context, India predominantly in most of the DTAAs, it has FTS clause in place. India does not have service fees in most of its DTAAs. However, if service fee is present in the DTAA, it is very critical to analyze the interplay with the FTS clause. So the implication here is that if we have a service fee and the FTS article also applies, if a service fee exists, the income is taxable on net basis. We can claim expenditure and the net profit becomes taxable. However, if FTS clause becomes applicable, income is taxable on gross basis. So that is a critical issue we need to consider. However, there is no clear clarity yet. So we come to the last point on service fee. So we have something called stewardship activities and secondment arrangements. Stewardship activities mean that a non-resident or a company sends employees to its subsidiaries or other group entities to ensure that the group's standards are met, the work standards or any internal standards they have, the work adheres to the standards they have. Stewardship activities involve deployment of employees by a non-resident to India or to any source country. So will that deployment and the work trigger any sort of service fee implications? Because under stewardship activity, we are deploying employees from non-resident to the source country. The employee deployment requirement is satisfied. Subject to satisfying the conditions of time limit, will this trigger service fee? And on a related note, stewardship activities are slightly different from the secondment arrangements. Secondment arrangements are where the non-resident sends employees to another subsidiary or any other place of business in the source country, and the employee becomes, in essence, becomes the employee of the other place that he goes to, not the employee of the non-resident or the legal employer. So in such case, we need to first we need to understand the difference between stewardship and the secondment arrangement. Stewardship is employees are deployed to ensure that the standards of work are met, whereas in secondment arrangements, they move out, they work for them. In substance, they are employees of them. So the arrangement works in such a way that the employees under secondment arrangement gets paid by the employer for whom they are moving to. Say X company sends employees to Y company on secondment. Employees get paid by Y, and whatever employee gets paid by X, and whatever payment X makes to Y, X makes to employees, Y pays them. So whereas in secondment arrangements, that is not the case. Employees go there and they remain the employee of the the company sending them. Yeah, home company. So will this difference between stewardship activities and secondment arrangement, will this trigger a service fee? As regards stewardship activities, it has been held that stewardship activities are for protecting the interests of the shareholders. Stewardship activities are generally undertaken by holding companies to ensure that the internal standards are met. It is to protect the interests of shareholders. It does not give rise to any service to the person or to the company they are sending. When they are providing service, some sort of benefit should accrue to the person. However, it is to ensure the personal interest of the holding company is protected. So stewardship activity should not give rise to the way. However, secondment arrangements, it is a service. The legal employment, the lien on employment is the key term. The employment remains with the home company, the original employer. Since the employment remains with him, we cannot say that the services he provides or whatever work he does is for the other place where he goes to. So secondment arrangements does trigger fee, whereas stewardship activities does not trigger fee. This is the broad ruling. This is the high level, rules set by the Supreme Court judgment in the case of Morgan Stanley. So, stewardship activities does not give rise to a shareholder, a service fee because it protects the interest of the shareholder, whereas secondment arrangements give rise to a service fee. So that concludes the high-level discussion about permanent establishments. So before we go ahead and discuss about the attribution of business profits to permanent establishment, I'd like to touch upon some practical considerations. Any specific fee, be it a fixed place fee, be it an agent fee, be it a service fee or a construction fee. Any fee arising in India, what is the practical implication for the non-resident in India? Firstly is the tax implications for the vendors. Rather than the non-resident, it is the vendors who should be worried about the TDS implications, considering the disallowance and the interest they need to bear and the 201 proceedings, TDS proceedings risks there. And if PE arises, there are two options available to the non-residents here. They can either voluntarily, disclose that they have a PE in India, or they can dispute the existence of PE with the tax authorities. Supposing if they voluntarily go for PE, in that case, it needs to be seen what will be the tax impact for them, because once they say the PE is existing, they need to maintain those complaints. Factors coming to play. They need to get registered as a company. They need to company or any form of business, and they need to obtain PAN. And TDS deduction for foreign companies' taxes are deductible at 40%. Will that be, that will again be a challenge with the vendors. So, and then looks I said RBI guidelines come into play. The tax rates are different. So all these complaints aspects come into play, and typically the tax authorities say that PE arises and they apply a blanket rate of the global profits. Say for example, a non-resident having a PE, or the tax authorities say that a non-resident has a PE. In that case, they just apply a blanket rate on the total receipts they consider. Say for example, a total receipt of 10 crores has accrued for the non-resident. In that case, they say a portion of this 10 crores, say 50% or 40% is taxable as profits, taxable as income, and out of this, a certain portion is taxable as profits, and so on. So these arbitrary methods are being employed by tax authorities to, bring in PE implication, PE related taxation aspects for non-residents. And it is important for the non-residents to understand the impact and, structure the transaction suitably, whether to set up a subsidiary in India or to structure the contract in any other fashion so that PE implications are avoided. That said, if you have any specific questions.
Once you say I agree that yes, I have has a PE, does it automatically mean that they have declared the global income?
No, they need not declare global income. So I
There is no risk of global income being taxed.
So I've personally seen a case where it's a big group, global automobile group. They have their financial statements available in public domain. So they go to the extent of researching the financial statements of the holding company, the ultimate holding company. Say that they have a permanent establishment in India. Say that certain portion of it is taxable in India, whatever amount they consider, and they apply the global profitability, the net profit percentage of the global consolidated financial statements or standard financial statements. They consider that and apply the percentage on the gross versus whatever they compute in India and say that it is taxable in India, rather than undertaking a clear-cut attribution or clearly saying that this is how this is done. They resort to such arbitrary measures.
So when we are supposed to detect TDS number 95, we get the no PE certificate, right? So if the non-resident has a PE, then it is not the question of whether 10% as per TDA, then it will be 40%.
So that's on B.
At 35% should be technically on the profit margin, right?
Yes.
So how does the vendor calculate the profit margin? Can vendor apply similar basis or on the entire gross amount that we have?
That's the key part for the vendor. That is where the challenge comes in. Vendor cannot arbitrarily apply such measures. This is a mechanism that tax authorities are following.
So what is the rate that they pay? I want to know that as well. Can it
This-
be based on the double taxation? Can it be based on the treaty rate or
It is mostly based on the treaty rate.
but if there is PE?
If there is PE, it needs to be at 40%. But what is the portion of income that needs to be, or the percentage margin that needs to be discussed with the taxpayer or the non-resident? Typically, they don't voluntarily disclose. That's a hypothetical scenario. But I just wanted to bring in the practical aspects if they have a voluntary. In case, if it is a disputed case and it turns out that they indeed have a PE when they have where they have given that they don't have a PE, in that case we can safeguard ourselves saying that we have a declaration.
Yeah, if that's the case, it's fine. But if they have actually given that there is PE or in a scenario of secondment,
Right.
when the reimbursement is happening, right?
Right.
So it is a very clear cut case of there is a PE that is.
So in that case, practically how it happens is we deduct on the gross amount. We deduct on the gross amount at 40%. Yeah. If they say that there is PE, we deduct at 40% to safeguard ourselves from the reverse of previous provisions.
So there is a PE, then obviously for foreign company 40% rate comes. How does this differ from the poem provisions that has been said? What is the basic difference between this PE and the poem thing classification? So ideally poem also comes to a conclusion. If a non-resident has a place of effective management, then again the similar 40% things comes up, right? So what is the difference basically? Why there are so much provisions?
Yeah. So poem is to see if the person is a resident in India or not. If the person satisfies the poem conditions, he becomes a resident. Even if he's a foreign company, he becomes a resident of India. So his global income becomes taxable. Whereas for permanent establishment, only income
40% is the max rate that can be. So when a non-resident comes to a contract, so do we need to check only the PE or the poem also, whether he is applicable or not, whether he is getting himself as a resident here? Do we need to go for that aspect as a vendor or only the PE?
That need not be undertaken because poem aspects are, poem risk lies with the company, not with the vendor. If the poem risk arises, it's the income of the company that is getting taxed.
Okay.
So the vendor need not, it's for the transaction with the vendor and the overseas non-resident person. Right? It's for the transaction with them.
So he basically declares himself as a resident if he
becomes a resident.
So again, resident provisions will apply. Resident TDS provisions will apply.
Resident, he'll become a resident. He'll still be the foreign non-resident will still be a foreign company, but they will be treated as a resident for tax purposes. So the tax rate applicable for foreign company will apply, but the provisions of resident Indian will apply.
So supposing in your case, the vendor is given information that he has PE in India, and in the earlier example, the aggregated formation was based on 45. So it's a straightforward. But still, certain vendors, based on the agreement with what we have, so they tell like whatever tax incidence happens in India, that entirely it's your responsibility, and we resort to crossing of the payment. So in those cases, ultimately the vendor will get, the non-resident will get the ultimate what he need to get as per the invoice value that he will take. So ultimately we end up paying the more taxes on crossing of the. So in that case, anyway the non-resident is not going to file any return in India.
Okay.
So what is the ultimate objective in that case?
That's a business call. That's a business risk that vendors are running. So when you say
look at it, most of the foreign vendors, they have this clause by default in the agreements. Wherever tax incidence happens in India, it is entirely your responsibility. The non-resident will not bear any taxes in India.
Correct. So it is upon the vendor to talk out the terms clearly to say that if because vendors are clearly capturing those points in contracts, especially turnkey contracts and other big construction projects. They clearly say any issues related to permanent establishment or income tax aspects whatever they had to pay out in excess of what they are legally required to do, that needs to be indemnified, that needs to be reimbursed. So the vendor needs to be proactively cautious to
Whether the process is fine or in that case it shouldn't result in process. Because normally most of the foreign governments are done on a personal basis. Because vendors don't typically agree for withholding in India.
Correct.
So this is a legal term. Actually, recognized rules provides a provision for how to process it.
Correct. So whether 40% or 10% crossing up is the right way to do. But again, the interest of the vendor is impacted here because the non-residents don't bear the tax portion, tax cost.
So including those even 56 certificates are given by CES.
Correct.
So the company who's paying remittance from India, they will be in default. Because anyway the non-residents won't file, it's not written by regulation.
Just the vendor is at the risk here.
Who's person making
The payment, he is at risk here. Because, sorry, I was saying vendor, so the customer, the pay, they are at risk here because they run the TDS risk like you said. But contracts also bring in this aspect of, including the related tax component in the contracts itself to say that anything, based on the declarations you have given or any other supportings you have given, the tax component we have deducted is lesser than what it ought to be or what it should be. Then for the non-resident need to make good for whatever additional cost the Indian pay is there. So contracts are, including that as part of the agreement. So it is upon the onus is upon the vendor to be cautious in that.
So PD has more relevance when it comes to this problem. When you look at other articles like the loyalty or FPS, there is no mention of PD in it.
Correct.
If you read the article. So in that case, whether irrespective of whether the vendor is having PD or not, whether we can go on to the rate mentioned in the PD itself.
Yes. Yes. So there is this concept of attribution of profits if the royalty or FTS payments being made to overseas entities, if they are attributable to the PD. Your question is, the non-resident has a PD and there is a royalty payment, right? If they are attributable to the PD, in that case, 40%.
So that is basis the declaration from vendor.
Yes.
If he provides a declaration that there is no PD relation to this royalty, then we can go ahead with that. But anything in any instance, no PD declaration will be a mandatory.
Correct. Because it is, like you said, it's a very costly risk for the payers, Indian payers. They need to have sufficient documentation to say that they have deducted at a lesser rate based on the declaration given by the taxpayer. They cannot undertake an independent P analysis for the non-residents. So, based on the declaration they have given, they can substantiate their position by saying that it's based on, a genuine declaration. We believe that it was a genuine declaration from them. So, that is practically how it is.
What is the relevance of having a holding subsidiary? If there is a subsidiary in India, that doesn't constitute having the for the holding company. If holding company is not having any transaction with its customer directly, so merely having a subsidiary in India, because that's an independent entity, right? So that does not constitute the. But if the subsidiary, there was one point I think in agency or PEI was a point. So if that is triggered. Suppose the local customer is won by the holding company through the activity of the subsidiary, and the dependent agency is established, only then PE kicks in, right?
Correct.
So, and also ma'am was referring to a place of effective management. So again, most of the companies, if you look at the subsidiaries that are incorporated in India, especially in IT sector, right? So it is only for outsourcing their whatever project that they are getting in US, Australia, Singapore. So for the manpower here, and then it is billed to the holding company on a cost-plus basis. Correct. So in this case, technically the management is completely, is driven by the holding company. So will this constitute that the holding company is a resident of India? the base of effective management and service?
Firstly, you're talking about POEM?
Yeah.
Okay. POEM, sorry.
Yeah.
POEM, it needs to be analyzed independently. Just because they have control over the subsidiary, I don't think POEM provisions will have any relevance. POEM analysis is a separately altogether exercise, altogether different exercise. It depends on the board meetings they can do, whether they have active business outside India or not. The test is totally different. So these considerations are not part of those provisions. So mere existence of subsidiary will not give rise to POEMs.
So, and also mere existence of a subsidiary doesn't trigger a PE for the holding company.
Correct.
Also, one more about the holding subsidiary relationship. Supposing the holding company secures a contract in India, and the contracts are directly, the payment for the contract are directly made by the Indian company to the holding company and abroad. But the servicing of the contract, say for example, installation of machinery or kind of thing. So if it is done through a subsidiary company in India, will that constitute a service fee? They have a subsidiary company in India, but the entire work and so outsourcing everything is done directly by the parent company outside India. And the payment is also received from the Indian company outside India, directly to the parent company. Only the servicing part of it is done through this subsidiary company in India to save their traveling costs, etc. So in that case, then we have no, the Indian company has no direct relationship with the Indian subsidiary of the foreign.
Correct.
So in that case, whether the service fee will be good.
Service fee, again, we talked about other person. If the work that needs to be undertaken is undertaken through other person other than through employees, in that case, whether the other person also is subject to the same level of supervision the employee is subject to, that is required to be seen. If the subsidiary is on the same, the work done by the subsidiary is on the same footing or supervised in the same way, the work is undertaken by the employee of the holding company. In that case, service will be
Technically, there will be a service contract in this between the holding and subsidiary. And I think this can be proven as not a PE, right?
Yes.
Since a service contract is established for them. And the supervision is from the employer's side or from the ultimate customer? From the employer.
But in that case, anyway, the same level of supervision is there. Whatever the holding company has to do, he is doing it through the Indian subsidiary. So typically, this work is only given to the subsidiary.
We cannot straightjacket say that that can be the case. There could be agreement terms, say for example the contract could be such that the holding company indemnifies itself with the subsidiary company for any service related aspects or any factual aspects needs to be taken into account in that case. But if the work done by the subsidiary company is subject to the same level of supervision or same level of control, like the work done by the employees of the holding company, it will be restored.
In that case, also the burden of punishment will have itself. If it is only
Yes,
necessity,
yes.
then it won't trigger a fee. It should be a minimum for understanding.
Here in the same example, if PE is triggered, the revenue for the holding company is actually through the ultimate customer, it's going to be passed on. And the Indian company is anyway going to pay the taxes, service charges, it's going to charge the holding company. Yeah. So here, let's say PE is triggered. Okay. For the holding company, the revenue is directly flowing from the ultimate customer. Yeah. And there will be a service contract between the Indian subsidiary and the holding company, and this is going to be entered into. This will be signed off, and for that, Indian company is going to pay taxes anyway. So in that case, it will go into the Indian company is a service provider, correct? So it will be charging the holding company.
Correct.
So holding company is going to pay Indian company for this, and because the PE is established, what additional implication there would be? Probably whether the transaction has happened at arm's length. Anyway, this could be there because it is a holding company and holding subsidiary relationship. So now, because the PE is established, what additional implication it is going to have this transaction?
In the hands of the entity or the group as a whole?
Group as a whole.
Firstly, for the PE whether they need to file a separate, like I said, attribution is a important aspect that we need to check. Transfer pricing is again taken care of. Return filing will be mandatory aspect that we need to consider. Then communicating with the vendors, the point he brought in, that is a very critical aspect.
In the return, it will be a nil return in that case. Because
they have a PE.
They have a PE, but the transaction is happening at an arm's length. It is a proper commercial transaction between the holding and the subsidiary company. And subsidiary company is offering it to taxes in India. So in that case, then it will result in double time offering it for the taxes, right?
Only income that is attributable to the PE. If it is attributable to the PE in India, then in that case it will be taxable. So if the payment is made directly to the holding company, even if you have a PE in India, it will not result in taxation.
If the holding company is able to justify whatever is attributable to the PE, anyway that has been offered by way of cross-charging between a holding and subsidiary company, and the profits are already offered in India, why do I need to again offer, as a PE? So that would be a scenario, right?
Yeah, this is a factual point that we can make. So actually, we can say this is essentially leading into a double taxation, and it is anyways being offered taxes. But to set the technical aspect right, if the payment made by the subsidiary company to the holding company is in relation to the PE that the holding company has, it will be taxable in India. It will again be litigated, but then again the income you offer for the holding company, it will again be treated as expense rate. Of course, you mark it up and
so it will be along with the markups. That's why if there is no markup, then it's not a constant anyway.
Yeah.
So the subsidiary can say that, see, for this, whatever activity has done in India here, for that I have actually built the holding company. Indian government has actually made money out of it, the taxes are paid. So there is no further attribution for it. So I feel probably as a PE, returns are to be filed without offering any income, because the company has to say that already the income is offered in the returns of the subsidiary. Maybe that stand will be okay.
That will not actually be okay, because income is accruing to the non-resident. So the mechanism of the income recognition for the subsidiary is not relevant for is not taken into consideration at all. So the income, whichever way, whether it is offered as a markup by the resident or not, income is taxable. Income is taxable in the hands of the non-resident. They cannot escape the requirement to file tax returns. However, the payment, having a markup and then again offering it as income, I think it's. Let me check that aspect and come back to you. What you're saying logically makes sense, but that's my initial thought is that we have that is the way they recognize revenue. That's the model they operate in. So, like you said, they have TP margins in place. So, all these aspects are factored in. What you're saying logically makes sense, but I have not seen any legal support to substantiate your stand. I can check that back and we can discuss about that. We come to the last topic, which is the business profits. So, when we talk about business profits, Article 7 discusses about business profits in any detail. It says that any business profit earned in India is taxable only if there is a permanent establishment in India. So, the entire understanding about permanent establishment circles around this requirement under Article 7. So, this profit attribution is a very, very fact-specific exercise, like the permanent establishment analysis. The essence of this is that we need to understand the kind of functions that the holding company does, the non-resident does. We need to understand the risks they assume, the FAR analysis we say in transfer pricing. We need to understand the essence of the activities undertaken to see or to understand the reasonable attribution that can be made for the activities they do. So, in that context, we'll discuss about business profits. Profit attributable shall be computed as if P is separate and distinct. So, I think that broadly answers your question. P will be treated. It is of course the extension of the holding or the non-resident, but for the purposes of attribution, we need to consider that as a separate entity, and any income that P earns is separately taxable, and that needs to be offered in India. And these are broad principles based on which the attribution happens. We need to understand that or assume that P is engaged in same or similar activities as the enterprise. So the non-resident, when they have a PE in India, they are basically an extension of the non-resident. They are not a separate engagement. They basically do the core business activities of the non-residents in India. So since they are an extension of the non-resident themselves, that is the basis we need to adopt for the purposes of attribution. Operating under same or similar conditions as that of the foreign enterprise. So they carry out the same business operations as the non-resident and wholly and independently dealing with the foreign enterprise. That's a mistake. It should be wholly and independently dealing like the foreign enterprise. So, like how the foreign enterprise deals with its customers, the PE also engages with its customers in a similar fashion. That's the idea. And I mentioned about FAR analysis, a detailed understanding about the kind of activities the permanent establishment undertakes and the kind of risks they assume needs to be understood to see the reasonable attribution that can be made. I forgot to discuss about one important aspect here, that is about force of attraction. So force of attraction talks about supposing a non-resident has a PE in India and that and through that PE some business operations happen. Some similar business operations are undertaken through any medium other than through the PE. In that case, any sales made through the other medium will also be taxed in the hands of the PE. That's called force of attraction rule. So it says that anything similar that happens in the country that PE exists will also be taxable in the hands of the PE. Luckily, India has not adopted force of attraction rule in most of its tax treaties. But UN model has, like I discussed, UN model is adopted by the developing economies. So UN model has a force of attraction rule in this.
So is it like if there is a PE for a non-resident, that means that the income earned, the consideration that he receives through that business, it is basically an income from business for the non-resident. That's what you're trying to say. So what if the consideration he tries to deposit over a bank and if he gets some interest income, should that be considered also as a business income, or like the force of attraction, that is the thing that you're trying to say, right? Through other medium, other than PE, if he earns some income, that India doesn't adopt that rule. So அப்படி நம்ம பார்க்கணுமா இல்ல IFOS மாதிரி தனியா
similar activities they undertake. They deposit the consideration, that's a different medium. If the deposition of the money in bank and earning interest through it is attributable to the PE, it will be taxable in the hands of PE. Otherwise, it will be taxable under normal provisions. Like we need to check for.
What is it attributable to P? Is it some kind of definition or what?
So yeah, attributable meaning we need to undertake a detailed FAR analysis. So for example, they do X functions. For X functions, what is the consideration might have the total amount they agree in the contract will have n number of functions, of which the activities they do will only be related to some portion of the total consideration. So only that portion of income that is attributable to the P. Say for example, they undertake various work, 3 to 4 works in India, and they get P risk for only one activity. In that case, whatever consideration is related to that activity only gets taxed. That is the process of attribution. So in this exercise, the activity of undertaking 4 different operations, they need to understand what are the functions they do. In the large scheme of the contract, taking the holistic picture, you need to understand each of the activities undertaken, and based on each of the activities undertaken and having a strong understanding about the risks they assume. That's called FAR analysis. It's a TP transfer pricing work. So based on that understanding, we determine what sort of attribution that should happen. So attribution is that understand the type of work they do and see the reasonable amount of money that can be said that that is taxable in the hands of people. It is again, there is no clear-cut rule as to how this needs to be done. There are judicial principles, but broadly it's in line with the transfer pricing provisions. If the transfer pricing provisions are complied, this broadly becomes compliant with the attribution requirements. There are also ruling we have discussed about Morgan Stanley ruling. In that ruling also it has been mentioned that if the P has complied with the transfer pricing provisions, it need not specifically undertake any specific attribution exercise. So basically attribution exercise is a TP exercise for FAR analysis you do. So if that is specifically done, then no other specific attribution is required.
So after that TP difference thing, if it is attributable then at business profit rates or else at a normal rate other than.
Sorry.
See, for example, in the bank example, the interest value, you say like if it is attributable to P, then at this business profit income, or else if it is not done through this transfer pricing exercise, if it is not attributable now, it is like similar not resident to under payment money.
In this case, the profit attributable to P, that portion will be taxed as a non-resident P. This P might be an Indian person.
The P is an extension of the non-resident.
Your earlier example, starting slide, so you showed me what and all constitute P. In that one of the cases, the branch, office, factory, etc. they are also listed as P. So in that case, factory, meaning you mean non-resident setting in factory in India, not an Indian factory. Indian factory anywhere in which an actual persons are subject to tax in India. So only the P will be the tax attributable to P will be taxed as P as an extension of the non-resident.
But what would be the nature of entity in that case if it is a factory? It would be a subsidiary, usually it will be set up against a subsidiary or a branch of it.
Yeah, it will be in the name of the company itself. Non-resident. You need to get specific approvals from RBI for setting up such factory without getting incorporated in India. So specific RBI approvals needs to be obtained for such a setup.
So if the factory happens to be an Indian company, setting up a factory on behalf of the foreign, then that doesn't constitute the because this Indian company is anyway subject to tax in India as well as
Again, it's a fact specific exercise, like I said, we need to check for agency P and all that. Separate P exercise can happen, but if the Indian company is not on pay, acting on behalf of the non-resident, and Indian entity is not being used to carry out whatever the non-resident wants to undertake, operations in India. That
It
is,
can happen, that way also. Supposing the non-resident, if
No.
they want to circumvent the provisions, they can have a natural person in India to set up a company on behalf of them.
okay.
By a factory or whatever manufacturing company they need to do. They can do it like a non-resident company. Then the instructions and everything, it can be given by the
Yeah, it
non-resident.
can happen, but it needs to be seen from the business standpoint. Whether in the, say for example, independent customers are being, serviced, or independent customers are being addressed artificially through this entity.
Because in the other example, holding company, subsidiary company, ultimately subsidiary company or foreign holding company will obviously service to their holding company. They may not have an external third party in India. They will be servicing mostly to the parent company.
Correct.
So in that case, even they can go through this route and
That is critical to again. We need to check for the principles here, whether there is any dependence or not. We talked about economic and legal dependence. Whether they are economically dependent on the.
my example obviously is because they don't have an external customer in India. They function only maybe for the parent company elsewhere.
In that case, we used to, even though they have a separate entity, separate subsidiary, the subsidiary will be treated as an agent.
So in that case, double taxation will come. Subsidiary company will also offer tax, and even the holding companies.
So how that happens is any payment that is not subject to the, say for example, any goods purchased or any specific business receipts are received by the foreign company from the subsidiary company. That will not be subject to TDS because of no PE declaration. Correct? So in that case, whatever is the amount that is paid without deduction of tax, or whatever is the amount that is paid based on no PE declaration will be subject to tax.
The agency fee is only if any income the holding company has made through the subsidiary. Let's say subsidiary also has its own activities, even if it is billing entirely to the holding company also. If there is an agency for let's say for one particular transaction, a new customer has been acquired through the subsidiary, the transaction has happened to the holding company directly. So the subsidiary company has not offered any income. In that case, whatever is attributable for that one transaction, it would be considered as fee, correct?
Correct.
So not the entire operations of the subsidiary will be considered as
No. But then again, we need to say, it says that habitually exercises the authority to conclude contract. So whether the agent is, doing this habitually on a regular basis, or is it an isolated transaction?
Okay, so if it is like one-off case, then
One-off case, it will not have legal agency.
In this example, suppose parent company P, they got about 1 crore rupees as income attributable to PA. Suppose subsidiary company is making invoice of about 70 lakh rupees or regular their cost. Means the parent company P, the net amount will be 30 lakhs tax payment.
So you're saying 1 crore is the payment received by
Income attributable to the PE Act.
to the PE.
But the subsidiary company, they are only doing the service.
If they are
They require some cost.
correct.
So they raise the invoice cost plus some
Cost plus.
say example, arm's length, they made an invoice, say 70 lakh rupees. They require the cost. They offer that income. So that 30 lakh only is the net income for that activity for the parent PE.
So in this case, we need to see whether the 70 lakhs paid by the subsidiary,
Whether we can detect that.
whether it is related to this 1 CR or something we need to see. If it is not related to the 1 CR, it will not be related. If it is something that is related to the PE, if it is something that is integral to the 1 CR receipt, 1 crore receipt that the holding company has, if it is integral, then we can deduct, saying it is an expense for us. But So if that is not the case, if we cannot substantiate that, then RCR. Any further questions?
The first slide that you were referring to, business connection, right? Only if there is no double taxation avoidance agreement, we will have to solve the business connection.
That is not the case. We usually resort to DTWS to CP analysis because business connection is a wider term.
But if there is no double taxation avoidance,
We have
we'll have to qualify.
we have to
So in that case, all these PE interpretation, all that would be
that comes under. So all the PE aspects are applicable only for non-residents, and only case where this, we fall under business connection and try to avail the treaty benefits.
We don't follow the business connection,
Correct.
Then what does the treaty say regarding the business profit? Does it have an double taxation avoidance by giving a credit for something?
Yeah, so that's a very good point. So if suppose a non-resident has a PE in India and profits are attributed in India and taxable, such income that is taxed and the tax that the non-resident pays in India will be available as foreign tax credit for the non-resident in their home country. So they will be able to deduct the taxes they pay here as a credit against their tax payable in their home country.
Supposing if they are having losses, in that case they cannot claim. If they offer something as tax in their country,
Correct.
then they will be, this
Becomes
becomes
a
be
cost.
offset as a tax credit.
It cannot be. That's a very important point for FTC issues. Say for example, some companies have higher withholding tax credits in overseas but have losses. Can they claim a refund from the home country? Home country usually they don't accept such practices. In that case, some countries, I think Canada, some other countries, they adopt this practice of roll forward and roll back of tax losses. It's a mechanism to carry forward this credit, refund credit to years, and the losses along with the credit can be carried forward to next year's, something like that. So rather than claiming it as refund, they set it off against the next year's tax bill. Thank you all for